Hello, everyone. Welcome to episode 32 of the Fair Housing Insiders. We are so grateful to have you on our show today. Today is a very special episode. A few months ago, we released episode 15 that talked about emotional support animals, one of our most popular videos to date. In that video, there were a lot of comments in our YouTube channel, so we thought we'd take this opportunity to address some of those comments, answer some questions. And what was interesting is there were some comments, not only from people within the property management industry, but even from some residents who had some comments on this subject. So as always, we are grateful to have Kathy Williams with us on the show. Kathy, how are you doing today?
I'm doing great, Jonathan. I think this is a good idea to take one of our videos to answer questions from a past video. We try to make our videos short and concise as we can. And in doing that, sometimes we skip over material or don't spend enough time on material. And therefore, there are good questions that arise. So we're going to just take some time today and answer directly some questions that have been raised about the topic of emotional support animals, which is definitely, as Jonathan said, one of our most popular videos. It also is probably a topic that when I do training, I get the most questions about. Right. And the more we can clarify that, the better. I also want to mention that as we're talking about this, and this is one of those topics that people have very strong opinions about, we are not talking about our opinions. We are trying to convey in practical terms what the law requires of housing providers. That is always our goal. And so we're not giving you legal advice here. We're just trying to clarify what the law requires of you as housing providers. And please keep those questions coming. We are happy to answer them whenever we can.
Yeah, very good. Thank you for clarifying that. Yeah, this is not an opinion piece. Our show has been very popular for that reason. Very, very clear and distinct. We appreciate your insight and your years of experience, Kathy, as an attorney in fair housing, to be able to help our viewers in our community. So just as a reminder, if you haven't seen episode 15, click on the link in the show notes or here on the channel itself, you'll be able to find that. Episode 15, we really dug into that subject of emotional support animals. So let's get into some of the comments and questions that have come from our community. So the first couple, Kathy, came from some conversations that you have had with clients. So the first one that you provided for me that you had a discussion on had to do with a new resident's guest bringing a dog onto the property. And they were told that guest animals are not permitted. She became very angry and told me that the dog is her service animal and she takes it everywhere. And I was violating the law by telling her that she can't bring it when she visits her sister. So is that correct? What does the law state and how would you respond to that?
This certainly is one of the areas of a lot of confusion because there are two different laws and they are different about assistance animals. So the guest who was thinking that the property management leasing consultant was wrong on the law is because she probably takes her dog shopping with her. She takes the dog to restaurants. And in those situations, the people that work for those establishments are very limited, what they can ask about the dog. Mm-hmm. But that's not the situation when she brings that dog onto your property. When she does that, a different law applies, and that's the Fair Housing Act. And the Fair Housing Act permits housing providers to ask for verification of need and that person is indeed disabled. So, just like your usual reasonable accommodation process for assistance animals, you would apply that with a guest assistance animal. So you're looking at two questions. Is this person actually disabled with the definition of the Fair Housing Act? And then, does this person need the animal because of that disability? So whether the guest thinks you are being proper or not, you absolutely have the right to follow the Fair Housing Act as a provider of housing instead of the different law that applies to stores and restaurants and other places of public, what we call public accommodation.
Very good. Excellent explanation. Yes, I like how you differentiated between restaurants and other businesses, shopping and housing. Very, very distinct laws for each. So appreciate that. So the other conversation that you referenced, Kathy, was about a resident who mentioned that they were terribly afraid of cats and that he had moved into a no pets property just so that he wouldn't have to live around them. Mm-hmm. So should I inform him that his neighbor has an emotional support cat?
And the answer is no, because you shouldn't be sharing that kind of confidential information about one resident with another resident. However, I think it's fine to give that resident a general understanding of the fact that even though it's a no pet property, there either are or there could be at any time assistance animals living on that property if the resident needs the animal because of a disability. And some of those might be cats. So I think the resident needs to understand the realities of even living on a no pets property. You may live next to a cat. And hopefully, since it is a cat, not a dog, they won't run into it. And if they do, then you'll have to address issues about how to, as comfortably as possible, make sure that both residents' needs are being addressed. But at no time could you ever deny the right of a disabled resident to ask for an assistance animal because their neighbor doesn't want it, doesn't like it, is afraid of it, is allergic to it, or anything like that.
Okay, very good. Very unique situation for sure. So appreciate your feedback on those. So our next set of comments and questions are coming from our YouTube channel. And so we are going to give a shout out to George Senda. So his question is, he's a resident, I would imagine, coming, based on the question itself. What if you have two previous managers that allowed 3 cats and a new manager hates cats and demands that one be removed? That his 3 cats have been with him for 15 years. My doctor has given me an ESA letter. So that's George. Thank you, George, for contributing to the community. Any comments on that at all, Kathy?
Sure. And I certainly don't want to give George or anybody else legal advice, because what we're trying to do on this channel is make sure that George's housing provider does the correct thing, follows the correct procedures under the law. So if George asks for 3 cats, as it sounds like he wants to do, then that request needs to be examined individually with all the facts pertaining to that situation. As you know, you don't apply certain policies, like we don't permit 3 cats. Well, you can't say that if it's an assistance animal or animals. Instead, you process it. And certainly the fact that George has lived there for 15 years with those 3 cats would be a fact that would need to be taken into consideration in the final decision, along with whatever verification he provides justifying those 3 cats. So Again, I can't answer the question. I can just say it needs to be processed according to the individual situation as presented in his question.
Yeah, very good. Thank you, Kathy. So this is coming, our next question is coming from someone in the industry, ST_G. We appreciate your question. So could a reasonable accommodation request be put into motion and verified prior to the applicant moving in?
Great question. And the answer is absolutely yes. The factor I would just talk about here is if you are processing a reasonable accommodation for an applicant, make sure that at every stage you remind the applicant that however this reasonable accommodation request gets answered has nothing to do with whether they are qualified for this unit or not. Right. So in other words, you're doing the processing of the request at the same time you're processing the application, but the two things are entirely separate. And it's not going to make any difference whether they are invited to live in your property or not. They may decide they don't want to live in your property if you deny their request for an emotional support animal, certainly, but that doesn't mean your decisions are going to be any difference based on the request.
Okay. Yeah. Thank you very much, Kathy. And thank you for the question as well, STG. So our next question comes from, I'm going to assume a Star Wars fan, Skywalker 567. And they say, great video. And we appreciate that. We love you guys. We appreciate your support of our channel. So thank you for taking the time to comment. So a little bit of a longer question. There's two parts to it. Does the requirement for the healthcare provider having personal knowledge of the tenant and their disability apply only to verification of the need for support animals? Or does it apply to all types of reasonable accommodations modifications, such as a disabled tenant requesting a reasonable accommodation due to an allergy to cigarette smoking by a neighbor? So that's the first part of the question. The second part, is the verification source required to have personal knowledge of the tenant and their disability in order to make a valid judgment to verify disability and the need for the requested accommodation? So thank you, Skywalker 567, for those questions. What do you think, Kathy?
Well, first of all, I just love that name. I happen to be a Star Wars fan too. But in response to your question, and you've raised really good questions. The requirement that a verifier has personal knowledge of the circumstances, the diagnosis of that resident applies across all reasonable accommodations. I think we talk about it more with emotional support animals because we see it so much. We see it more with emotional support animals, but the basic requirement is that when you can't tell if someone is disabled and needs this accommodation, whatever it is that they've asked for, then you have to rely on a third-party professional who can give you a reliable verification that the person's disabled and that they need the accommodation. And that to have that information, there needs to be some type of personal knowledge. Now, again, we always have to look at the individual facts of the situation. I am not saying that a medical doctor could not read a chart and say this person is disabled, okay? Because they can. I mean, that is reliable. If there aren't charts to read, if someone just makes that decision somehow from a telephone conversation, then I would maybe question the reliability. So again, it's it's hard sometimes to answer questions because we need all the facts in that situation. But I would say that there is a necessity of personal knowledge. How that personal knowledge is gained may vary among various circumstances. Did that answer the question?
Yeah, that was excellent. I appreciate how you there's a lot here in this question, but it's still open to so many other potential circumstances that aren't there. I'm sure Skywalker probably could have written 1,000-word blog maybe on this particular situation. So I think back to some of our previous episodes, Kathy, and why fair housing training is so important, and especially for something along this line, that you can't just have a cookie cutter approach to every single request for an emotional support animal. You have to do that due diligence. You have to look at the fact you have to do this. There's just so many things that have to be done, and you can't just be like, okay, here's the way we handle these and how we process these types of requests. So it takes some extra next level training, role playing, and so on for our on-site team to have that understanding of what they need to do in order to take each situation and process it correctly. Does that make sense?
And I think, Jonathan, in the video, although it was quite some time ago when we did it, I hope I talked about the fact that it is okay for a housing provider to ask a couple of questions to decide whether the verifier does have personal knowledge of this resident or not. And hopefully the facts of the circumstance will come out in the answers to those questions. So, it's okay, on your verification form to say, how do you know the resident? Things like that. So maybe they'll explain, well, I've been treating the resident for the last, 5 years, and then So that's maybe one way of getting to that information.
Got it. Very good. Again, Skywalker, thank you so much for that detailed question. Really helps our audience. We thank you for your input, and thank you again, Kathy. There's no doubt, I think, out of all the topics, Kathy, that you and I, Michael, Leslie have had on this show, this one has been, it lives up to the name of the title, Emotional Support Animals, and it is an emotionally charged conversation for sure, because it's not just the housing industry that has brought this challenge out. I mean, we hear things about what the airlines are going through, restaurants are going through, and the list goes on how to address emotional support animals. So a short question coming from, and I apologize if I mispronounce the name, Akiath Sabek. So forgive me if I did not pronounce that correctly. So the question, can you tell me if a landlord can deny an ESA dog for not being hypoallergenic?
Generally, no. That wouldn't be a reason to deny a dog, unless there are some very unique circumstances to take into consideration. For instance, if this were a roommate situation, or a situation where people lived all in the same area, then it might be a factor. But normally, whether the dog is hyperallergenic or not is not a factor to consider when you're processing a reasonable accommodation.
Very good. Thank you so much, Kathy. And our next question comes in from Northland Property Management. If you have two equally qualified applicants and one has a support animal and one doesn't, can you choose the one without an animal without being considered discriminatory? So thank you for the question, Northland Property Management. What do you think, Kathy?
The answer to this one is pretty easy. And the answer is absolutely not. You cannot consider whether someone has an assistance animal, because what that would translate into is you would be saying no to the disabled resident and yes to the resident without a disability. And obviously that sure looks like discrimination, illegal discrimination. So I think that's an easy one to answer.
Yeah, but we appreciate it because sometimes people have opinions and, that question needs to be asked. It's got to be very, very clear. So thank you, Northland Property Management, for bringing that question out. And we appreciate your support. So a couple more to go. Amanda Lauren, thank you for your question. So her question is, what exactly does the resident have to consider that animal an ESA, or an emotional support animal?
Okay, so this question could have come from either a housing provider or a resident. It could have, we don't know. But Amanda, what is necessary is first and foremost that the resident is disabled. And what that means is has an impairment that substantially limits one or more major life activity, and has a medical or therapeutic provider who will provide that information to the housing provider if asked in the verification process. So the resident has to be disabled, and the animal needs to be necessary because of the disability. There's got to be a connection between the disability and the animal, the resident's need for the animal. So when that is present, when both of those factors are present, then usually we assume that that animal can be acknowledged by the housing provider as an emotional support animal versus just a pet.
Very good. Thank you for that. Appreciate that, Kathy. And our last one for today comes from Vincent. If I disclose after being approved as a tenant, would there be a problem? So I'm assuming his question is, if I disclose that I have an ESA animal after being approved, would there be a problem? So what are your thoughts, Kathy?
I do think there might be a problem. So I would suggest not doing that if at all possible. And the reason is the housing provider should process requests, whether they come in before the animal arrives or after the animal arrives. So they should process it. There can be a presumption that the resident is not being truthful if they sneak the animal in, when it's clearly said in the lease that you don't bring an animal into your apartment to live without permission of the management of housing, of the housing provider. So while the housing provider should process it and make a decision, I think you're giving yourself one strike against you by not being truthful about the animal being there. So I would not suggest you do it that way. But for the housing provider audience out there, you still need to fully process that request, regardless of when it comes in.
Right. So honesty is always good. Keep that relationship going. I think that has nothing to do necessarily with fair housing, but just it's always a good life practice. So I guess it would be different though, Kathy, if someone is, they're already approved and they are a tenant, and then maybe some sort of health situation arises that puts them in that situation where they're in need of an ESA. That would be a different scenario, correct?
Well, the question is, do they bring the ESA in immediately without notifying management for maybe a month or two, and then notify management? That's the question. The question is, do you let management know you need to bring this animal in, you plan to bring it in prior to bringing it in?
Right.
And that's always, again, I've seen so many housing providers that when they find out by accident that animal has been living there for months and months and months, they assume the resident was just trying to avoid pet fees or
Right,
security
right.
deposits, and has nothing to do with whether this resident is disabled or not. So right away, they're kind of questioning the reliability of what the resident is saying.
Yeah. Yeah. Very good. Appreciate that. So thank you again, community. Thank you, Kathy, for taking the time with us today to address some of these questions. We're grateful that our community we're able to share that on YouTube and keep them coming. We thought this would be a nice opportunity to not only address these questions, but to thank our community for just being part of this. We appreciate so much your support. And along the lines of this topic, we wanted to also tell you that a new course is coming out. So our advanced fair housing course will be released Q4 of 2021. And one of the modules is very specific to emotional support animals. So for all of our housing providers, keep that in mind. Reach out to Michael Coughlin for more information about when that's going to be released and to be able to sign up your people to be able to take that course. So we appreciate how important it is to have fair housing education. So thank you, Kathy, for being on the show. It's been great to have you with us again today. This will conclude episode 32 of the Fair Housing Insiders. Make sure you check out episode 15 in order to have some context for the questions for this show. We thank you for being here. Please be sure to share this episode with your friends, with your community, and with your teammates. We look forward to seeing you on our next episode. Take care, everyone.